It is high noon on a beautiful Monday afternoon here in Oregon. Welcome to the drama-free true crime destination known as Bethea'S Byte. I'm Ernest Bethea, the last outlaw. So good to have you here with me this afternoon. And before I get started, once again, I apologize. Yesterday, due to circumstances beyond my control, I had to reschedule this edition for today, but I'm still giving you the same stories that I was going to cover on yesterday, including the four big ones that grabbed my attention, and you get to decide which one tore my heart in two. But before I do all that, I want to get to my weekly missing persons report. So if you will watch your screen carefully, normally this will be a normal missing persons case, but this is more in the vein of a kidnapping. The young man on your screen right now is Hansel Quiros. He was declared missing June 16th, 2023 out of Ontario, California. As far as vitals go, I only have the information that his date of birth is September 6, 2015. He is born in California. He is Hispanic, and these are all the details that I have on the case. Hansel Quiros and his father Felipe de Jesus Quiros Jimenez, who I'll show you in just a moment, are believed to be in Mexico City, Mexico, with the family of Quiros Jimenez. They also have ties to or may visit Guadalajara, Jalisco, Mexico, and Guerrero, Mexico. Here's all the details. The FBI's Los Angeles office is seeking the public's assistance in locating Hansel Quiros on July 16, 2023 at approximately 4 o'clock in the afternoon in Ontario, California. Hansel was picked up by his father, Felipe de Jesus Jimenez, for a scheduled unmonitored visit. At the end of the visit, Hansel was not returned to his mother, who shared legal custody of the child with his father at the time. It is alleged that Felipe de Jesus Quiros Jimenez drove Hansel to Mexico and was not returned, denying the child's mother her parental rights. Now let me show you the other gentleman in question. That's Felipe de Jesus Quiros Jimenez. It goes on to say that Felipe de Jesus Quiros Jimenez was driving a 2002 silver two-door Volkswagen GTI with California light. Wait, and before I read that off to you, let me show you the car we're referring to. Yes, this is the car in question, a 2002 silver two-door Volkswagen GTI with California license plate 7PHT055. There is a federal arrest warrant issued for Felipe de Jesus Quiros Jimenez on August 15, 2024 in the United States District Court, Central District of California in Los Angeles, after he was charged with international parental kidnapping. So guys, we really need your help here. If you have any information on the whereabouts of Hansel Quiros or his father, Felipe de Jesus Quiros Jimenez, please do not hesitate. We want you to call 911 immediately. We want you to call the Los Angeles FBI field office. That's area code 310-477-6565. 310-477-6565. You can also reach out to the FBI's 24-hour tip line. That number is 1-800-CALL-FBI, 1-800-225-5324. And you can submit your tips anonymously to the FBI. That address is tips.fbi.gov. tips.fbi.gov. Any information you can give can bring a step closer into, one, bringing Hansel back home safe, and bringing Felipe de Jesus Quiros Jimenez to justice. So as I always say, if you see something, say something. That way we can do something. Let's bring Hansel home, and let's bring Felipe to justice. All right? Ooh, oops, wrong button. All right. Now let's get down to what we normally come for. I got a full week of true crime I want to cover, including those 4 huge stories. So, first of all, welcome one, welcome all. This is Bethea'S Byte Reloaded, the drama-free true crime destination. I want to thank you all for joining me. And if you liking everything you've seen so far, I'm asking you to like, share, subscribe, drop me a comment here in the chat, drop me a comment in the community page. I'll be more than happy to respond to you. And it's also a free way to support the channel. If you want to, if you like to support the channel by cash, once I take this off your screen, there you go. If you'd like to support the channel monetarily, really just to help keep this bad boy going, then here are the options. Hit me up at paypal.me/EKB316, Cash App at $EKB316, or Venmo EB the Last Outlaw. And as my good friend Brittany J would say, nothing obligated, but always appreciated. Alright. If you'd like to join me up on the live panel, it's always open, but I have a brand new link. We'll talk about how I got the new link later. But if you want to join in, I would love to bounce a lot of theories, opinions, all that off of you, and you can bounce them off me. So come on in. Let's talk about these cases. Let's have a little fun in the process. To everybody in the chat, everything we comment on, all statements, all our views, it's all speculation, deduction, theory, and opinion. It's not until we find out that it's actually evidence. Until then, that's all we got. Speculation, deduction, theory, and opinion. Simple rules, easy rules. I'm not looking for any racism in the chat, homophobia, attacks, attacks on someone's dialect, their weight, looks, whatever they're wearing, their hairstyles. No spamming. We're not talking politics or religion. All I'm asking is you be respectful, period. Your opinions are indeed welcome here, but attacks on the others are not. If you hear something, you don't like this person's opinion, and you're in the YouTube chat, all you gotta do is click on the 3 dots to the right of the name, find that name, click block, and you're done. You don't have to hear from that person ever again afterwards. All right? You're gonna see this a lot during this. First off, this is the trigger warning. You will see something you will see something and you will hear something that may be triggering to your mental health. I say viewer discretion is strongly advised, and I mean that because I want to protect your mental health. Period. And of course, with every video, I will have this up at all times. This is only the shortened version of the copyright disclaimer. I have the full version either on the channel or in my own possession somewhere. I will break that. I will have that available for you when necessary. Right? And I gotta give my shout out to everybody at Court TV for all the coverage that they do. They do such a great job. That's the reason why they are the original true crime obsession. Court TV, your front row seat to justice. All right. I'll get to how you can follow me at the end of the video, right? But right now we're gonna go ahead and kick things off with this one. With our first story, this one was kind of sobering to me. A father is charged with stalking and murdering a Utah deputy. Investigators say texts between Hector Ramon Martinez Ayala and Marbella Martinez were more of the nature of a jealous lover than the father. I'll let you guys be the judge. The father of a Utah deputy found dead last month has been charged with her murder, calling the crime an unforgivable sin, and a text to a family member before leaving the country. 54-year-old Hector Ramon Martinez Ayala was charged with multiple counts in the death of his daughter, Marbella Martinez, including murder, stalking, and obstructing justice. The body of 25-year-old Martinez, who had been a corrections officer with the Salt Lake County Sheriff's Office, was found at the Tuel home she shared with family during a welfare check on August 1st. Her death was ruled to be suspicious, and her father, Martinez Ayala, was named a person of interest. According to the indictment, it's believed Martinez Ayala killed his daughter on July 31st. The cause of death was ruled to be homicide from strangulation. Investigators said text messages between the father and daughter were more of the nature of a jealous lover than a father, and that his behavior toward his daughter had become increasingly troublesome as he had become obsessed and controlling with her. Despite promising to change his behavior, Martinez Ayala allegedly placed a tracking device and hidden camera in her vehicle while she was out of the country, then using it to track his daughter and her romantic interest while they were away at Bates Canyon in western Utah. I'm going to stop right there, guys, and say, yeah, that does sound kind of possessive to me, kind of jealous to me, because simply, who puts a tracking device on his daughter's car? And the daughter's 25 years of age. I mean, I see where police are coming from when they say that that this is more of a nature of a jealous lover rather than a father. Surveillance video at the Tuel home showed Marbella arriving home on July 31st, followed by her father about 2 hours later. Court documents allege Martinez Ayala disabled or disconnected the home security cameras after arriving, and that video that may have showed him at the home afterwards was deleted or never existed because of the disabling of the cameras after his arrival. Just after 4:30 p.m. on July 31st, Martinez Ayala texted his brother saying, "My brother, you know how much I love you. I made a big mistake, an unforgivable sin. Now I'm too scared and I don't know what to do. I think I will never come back." Martinez Ayala then headed to Salt Lake City International Airport, disposing of his daughter's cell phone on the way. He then flew to San Francisco and Houston before using his twin brother's identification to leave the country. The current location of Martinez Ayala is unknown, but it is not in the United States. In my opinion, I believe that Martinez Ayala, he's running from justice because he knew what he did. He knew what he did, and he knows what's waiting for him. I mean, he texted that what he did was an unforgivable sin. He killed his daughter. He had what we like to call an unhealthy obsession with his daughter. And now she's gone. He's running from justice, ladies and gentlemen. It makes no sense. I mean, it's one thing if he's trying to protect her from any kind of harm or danger, but when you go as far as he did to strangle your own daughter just because you want her attention. You want her attention, and again, he's 54, she was 25. That's a very, very unhealthy obsession when it comes to his daughter's life. And now he's gonna run. And he's going to run tired. He's going to run to the point to where he can't run anymore. He's eventually going to get caught. And he's eventually going to have to face justice. Next up, we're gonna quickly talk about the Karen Reed interview from ABC's 2020. Karen Reed told ABC News that she felt an immense sense of dread as she searched for her boyfriend, John O'Keefe. Again, I gotta do this like I've done once before, and I want everybody to see me as I say this real quick. During the trial, and I now still have no skin in the game when it comes to Karen Reed. None. All I'm doing is following the evidence. I'm following testimony. I'm following everything that was said and everything that was presented. Anything less, forget it. Now, here's the article. Karen Reed's months-long murder case left her in purgatory and stressed every day, she said in an interview that aired on Friday night. 44-year-old Karen Reed is accused of ramming her into her Boston police officer boyfriend, John O'Keefe, with her SUV and leaving him for dead in a January 2022 snowstorm. Her 2-month trial ended in July when jurors declared they were hopelessly deadlocked, and a judge declared a mistrial on the 5th day of deliberations. This is no life. I'm not in prison, but this is no life. I'm stressed every day. I'm waiting for the next shoe to drop, Reed said in her interview on ABC's 2020 ahead of her trial. It just feels like a kind of purgatory. Last month, Judge Beverly Canone rejected a defense motion to dismiss several charges, meaning the case can move forward to a new trial set to begin January 27th, 2025. Prosecutors said Reed, a former adjunct professor at Bentley College, and O'Keefe, a 16-year member of the Boston Police, had been drinking heavily before she dropped him off at a party at the home of Brian Albert, a fellow Boston officer. They said she hit him with her SUV before driving away. An autopsy found O'Keefe died of hypothermia and blunt force trauma. Reed told ABC News that she felt an immense sense of dread as she searched for O'Keefe. She acknowledged having 4 drinks that night, some of which she didn't finish, but that she felt fine to drive. First off, I say, honestly, I don't care how much you finished. I don't care how much you finished. 4 drinks? You were definitely in no kind of shape to drive. Nobody is. I was worried he might have gotten hit by a plow. That was my first thought, Reed said. It was the only explanation I could think of for why John disappeared in thin air. The defense portrayed Reed as the victim, saying O'Keefe was actually killed inside Albert's home and then dragged outside. They argued investigators focused on Reed because she was a convenient outsider who saved them from having to consider law enforcement officers as suspects. After the mistrial, Reed's lawyers presented evidence that 4 jurors had said they were actually deadlocked only on a 3rd count of manslaughter, and that inside the jury room they had unanimously agreed that Reed was innocent of 2nd-degree murder and leaving the scene of a deadly accident. One juror told them that no one thought she hit him on purpose, her lawyers argued. Coming up at the end of this article, a little judicial common sense. The defense also said the judge abruptly announced the mistrial in court without first asking each juror to confirm their conclusions about each count. Reed's attorney, Marty Weinberg, asked Cano to consider summoning the jurors back to court for more questions. But the judge said the jurors didn't tell the court during their deliberations that they had reached a verdict on any of the counts. Where there was no verdict announced in open court here, retrial of the defendant does not violate the principle of double jeopardy, Cano said in her ruling. Prosecutors had urged the judge to dismiss what they called an unsubstantiated but sensational post-trial claim based on hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. Okay, guys, this is what I was talking about when I said a little judicial common sense. First of all, in a case like this, we're taking 2 months and it's in the hands of the jury. And the jury has but they deliberate and they say they come to a unanimous verdict on the one end, but they don't have that same confidence in it on another charge, or the jury is hopelessly deadlocked on all charges. It should be common sense to the judge, first off, to make the announcement that the jury is hopelessly deadlocked. That's the first thing. The second thing, it should be on the judge to ask both attorneys prosecution and defense, would you like to poll the jury on each count? That way, you will know for certain where that jury stands on all counts presented. Right here, right now, instead of that happening, and we find out for certain where the jury stands and which charges would no longer be entertained. We're gonna have to go through all this again next year, January 27th. This is why this case is such a mess at the moment. But as messy as it is, I will keep you updated. Next, Judge John Judge has granted Bryan Kohberger's request to move his quadruple murder trial from Latah County, Idaho. Yep. The change of venue motion. The change of venue motion will go forward. I'm going to take you to Court TV's Julia Janae and Kelly Craft as they cover this for you. So I'm going to mute myself and I'm going to get out of the shot while you get all of this all this report as Bryan Kohberger gets further prepared to face charges of the four Idaho students that he may have allegedly killed.
And welcome back to Court TV Live. I'm Kelly Craft, sitting in today for Ted Rollins along with Julia Janae. We do have some breaking news to tell you about. The trial out there in Idaho for Bryan Kohberger. The judge has granted the defense motion for a change of venue. So a big development there in that case out of Idaho.
Absolutely. The defense has been trying to get it out of Latah County, there where those 4 University of Idaho students were tragically killed inside of that off-campus apartment. And they've wanted to get it to a bigger county, Ada County, where Boise, Idaho, the capital of the state is. And now we are getting word into our Court TV newsroom that the judge is agreeing to let that change of venue happen. So this could really change how things unfold, especially for jury selection in this case.
We just got into our newsroom a copy of the judge's decision. So it's pretty long. We were taking a look at it. It went through all the details that are known so far in this case. And he really talked about the totality of the circumstances here, and that is exactly why he decided to grant this motion to change venue. I think we're going to bring in our guest now, Julia.
Yeah, let's bring in criminal defense attorney Joseph Tully, who is standing by. Joseph, we've been watching this case from the very beginning, and there was a question of whether the judge would grant this. It can be rare for a change of venue to be approved by a judge. Your thoughts on the judge's decision in this case?
Well, you're absolutely correct. It is incredibly rare for a judge to grant a change of venue. It's a very complicated motion, very time-consuming, and you have to hire, experts that bring in statistics, analyze media. Obviously, this is going to be an unpopular decision for a judge to take the sense of justice away from a community to try their own case. However, I think that the judge made the right call. These crimes were so heinous and so well covered on the media that even if there was if there was a conviction in the case in that town, there really would have been a big chance for an appeal to win based on trial was not fair. And so I think the judge made the right call, being able to move the case and preserving the sanctity of the jury's verdict.
The state was hopeful that it wouldn't be moved. Let's go ahead and play a little bit of the state's argument.
Finally, since we are talking about the interests of justice in the convenience prong of the rule, it is completely appropriate for the court to also consider the fact that most of the victims' families, not all of them, but most of them, live closer to Latah County than they do to Boise.
And that is something, Joseph, that the judge had to take into account. And again, in his ruling, we're just kind of getting through it right now, but it did say I have to take everything into consideration here. Obviously, that was one of the factors.
Oh, of course, yes. And that's why this was a difficult decision for the judge, because there's a community here and victims and witnesses and law enforcement, court personnel that now have to try this case, you know, away from the community at greater expense and greater inconvenience to the party. However, the judge has to weigh in terms of all total justice. Can this accused person get a fair trial? And in extreme situations like this, where you have an extreme case and, you know, the accusations are extreme, that's when you will see these change of venues motions are granted, but they're very incredibly rare. It's a very high burden to make. But I think the judge, like I said before, made the right call because otherwise, if there's a conviction in a case and it wasn't a fair process, then the defense can turn around and appeal and say, look at this media coverage. It was biased. This person, yes, they were convicted, but they did not get a fair trial. So I think in the long run, the judge made the absolute right call and sort of foreclosed that appellate issue by moving the trial now.
Do you think it will make a difference when it comes to these jurors and how many of them will be impacted by outside coverage, having known about this case beforehand? Because this was national news. And I do want to go back to what the defense said during this change of venue motion hearing that we covered that happened, of course, before this order came out. Let's take a listen back to that and get your thoughts on it, Joseph.
It's hard to imagine that one of those jurors who all of a sudden said, you know what, I'm not sure, and listened to more evidence and said, I'm really not sure. I don't think he did it. Are they going to be brave enough to do that, to write not guilty, to say not guilty, and to stand their ground? That comes right to impartiality. Imagine with me that we are here in June of 2025, and we're here, and we've seated 16 or so people over here. You're going to recognize some of them. People that sit in the courtroom in our audience that want to come and listen to the trial are going to see them. Even if they don't listen to the trial, people are going to know whose car leaves their driveway every morning to get to the courthouse by 8:30 for 3 solid months. And those jurors that sit over there are going to feel an immense amount of pressure to answer the call of the community to be safe.
And Joseph, I understand you've been able to get cases moved that you have handled. Just talk about that convincing of a judge, because sometimes when you have cases that are this high profile, judges say no matter where we go, people are going to know about this case and recognize certain parties.
Sure. So that is always a counter argument that a prosecutor can say is, look, Judge, everybody's going to know about this case. As you noted, this was a case that received national headlines. However, you have an extreme situation where you have a very small, tight-knit community where you just heard from the argument that there's going to be peer pressure, community pressure, and the saturation of the media coverage and the town talking amongst themselves is going to be so much greater in a small, tight-knit community. Whereas if you move it to a bigger city, a larger venue, you're never going to get a perfect jury. You're never going to get jurors who have never heard of anything, but you have a better chance of getting a fair jury. And that is what we want. We always want a fair jury, no matter how heinous the accusation, no matter how much media coverage the crime gets. We always need a fair jury for anybody. Anybody should be entitled, anybody in this country is entitled to a fair jury. So I think that the judge moving it increases those odds. And again, it's not going for perfection, because you can never get that. It's going for the most fair situation that you could get in any granted circumstance.
And Joseph, defense counsel really put forth a lot of arguments in regard to wanting this change. They brought in a lot of experts talking about just different media coverage. And there was some kind of analysis saying that where the murders took place, that with Washington State, actually the media coverage, the market, they were saying, was actually bigger. But I really did think that the judge was going to end up moving it just to, as we talked about in the beginning here, avoiding something happening here on appeal. Better safe than sorry, just trying to ensure that Kohberger, can get a fair trial. Any other thoughts on that?
Well, yes, that's exactly what you have to do to win these kinds of motions. You have to bring in multiple experts. And it's very statistics, a lot of statistics, and it's very thick. The expert reports are very, very thick, hundreds of pages long. And they go through every type of media, radio, social media, television coverage, and they analyze it in terms of raw statistics. And so those experts are very expensive, and the reports are very dense. And I think that that's just part and parcel of these motions. When people talk about change of venue, unless you have experts who can talk about pages and pages and reams of data, you won't have a chance of winning this. And here, because this is an extreme situation, they were able to win.
Kelly, when you mentioned Washington State, here's what it brought up for me. The distance. We were always thinking about the distance between Washington State, where Bryan Kohberger was a student, and the distance between the University of Idaho and where he would have had to travel. With this change of venue, and I know you've been to Boise covering the Daybell trial, but they're not going to be able to do any type of jury views in this case. The jury is not going to be able, I would think, and Joseph, I'd love to get your opinion on that. I don't see them taking this jury back out to Latah County to look at the location where the home was. We know the home has been demolished. It is no longer there, but they won't be going to any type of scene or driving along the same route that prosecutors allege Bryan Kohberger would have taken, because that's not even going to be an option if they are that far away.
I agree with you. So in that sense, this was a big win for the defense. However, I don't think this is a situation where it will make that big of a difference to the prosecution. That the jury field trips is what I call them, are pretty rare. We've seen them on court TV be utilized in a very positive way for the prosecution. Here, I think the prosecution will now rely on maps, Google Earth, that type of thing, rather than going to the actual scene. But in this situation, because the house has been demolished, that would have been the only reason I think that a judge would have granted a jury to go look at the evidence.
Yeah, good point. But even Julie, when you were talking, when we were out there for the Daybell case, a lot of us had been talking just because there's some downtime when you're covering your trial. Oh, maybe we'll take a ride up here. Mm-hmm. I mean, this is a big area out here in Idaho, and it was going to take us a long time to get up to the area where this murder took place. And so, yeah, to your point, you can't exactly have the jury views.
Sure.
Special thanks to Court TV's Kelly Craft and Julia Janae and criminal defense attorney Joseph Tully for their insight into this decision of moving Bryan Kohberger's case out of Latah County. And the word I'm getting is they're going to Ada County, where Chad Daybell and Laurie Daybell were tried. That's not in my opinion, that's not a good omen. That's not a good look, because if you remember how those cases turned out, Laurie Vallow was sentenced to life behind bars, and Chad Daybell is on death row. So you look at that and combine that with what Kohlberger is being charged with, the brutal murders of Ethan Chapin, Madison Mogen, Xana Kernodle, and Kaylee Gonsalves. They're moving his trial to pretty much the same courtroom that Laurie Vallow and Chad Daybell were tried. I'm not too sure how that's going to end well for them. As a reminder, if I can find it, that trial's going to start next year as well. So keep it right here to Bethea'S Byte Reloaded as we go as we keep track of everything Bryan Kohlberger. Okay, next up. Authorities have followed up on reports from an FBI tip line that someone had posted messages threatening to commit a school shooting. That's where we got our Georgia school shooting suspect. Alright, so now with that, I'm going to take you right to Michael Ayala of Court TV as we get more on that story.
Live, I'm Michael Ayala. We are getting our first look at an incident last year involving the alleged Georgia school shooter and his father. Jackson County Sheriff's deputies went to Colt and Colin Gray's home in May of 2023 after reports of an online threat to shoot up a school. The deputies first spoke to Colin Gray and then to Colt, his son. Here's the deputy's body cam.
Do you have weapons in the house?
I do.
Are they accessible to him?
They are. I mean, there's nothing loaded, but they are down. We do a lot of shooting. We do a lot of deer hunting. He shot his first deer this year.
Yeah. Okay.
You know, so like I'm pretty much in shock, to be honest with you. I don't know. I don't know anything about him saying like that, and I'm gonna be mad as hell if he did. And then all the guns will go away, and they won't be accessible to him. You know, I'm trying to be honest with you, I'm trying to teach him about firearms and safety and how to do it all and get him interested in the outdoors. Mm-hmm. Like on my phone.
And get him away from those video games.
Exactly right. That's the God honest truth. And the picture on my phone is him with blood on his cheeks from shooting his first deer. It was just the greatest day ever.
Yeah,
so he knows the seriousness of weapons and what they can do and how to use them and not use them. So it's kind of no need. Okay. It's kind of a little bit of a shock. So, in whatever y'all are telling him, please instill in him that if this is whatever, wherever this is coming from, it's no joke.
Yeah.
Like, it's no joke.
But we wouldn't be here if it was.
No, I know. And I'm telling you right now, we talk about it quite a bit. Okay. All the school shootings, things that happen.
Yeah.
All here. You getting picked on at school? He is. He's getting picked on at school, and is everything okay? That's why I keep going up there. Yeah. You know, because you never really know, and I don't want anything to happen to him. So these are good dudes. Just they're told.
Hey Cole, what's going on, bud? So did your dad kind of explain everything to you?
He said something about school shooting up a school.
Did you say something about school shooting?
They just told him, I don't know what. Maybe they misheard somebody else told him, never said threat.
You never ever said.
No, I swear.
Do you use Discord?
Discord?
Yes, sir.
I used to. I don't have it.
When was the last time you used it?
Like a few months ago.
Really?
Was it at Traditions or was it here?
No, it was a tradition because in that Discord account that I had deleted it before
Before you moved here?
Yeah, because I think it got like admin password pulled or something. Like I clicked on a link and somebody had.
Have you heard anybody on Discord when you were using it say something like that? You remember?
Like at that time?
Yeah.
I don't think so. I don't think I ever had anybody that
Never. And I mean, I'm not trying to get anybody hemmed up, but like, this is some serious stuff.
Yeah, I know.
Oh, he knows how serious it is, trust me.
I'd hate to, my boss was even like, I don't know how old this information is, and if you want to wait till Monday to follow up, I was like, nah, I'd rather do it now, because God forbid something happened in my job, I'd feel pretty bad about that. So I just want to make sure you understand that if something like that happened, or you hear something like that, report it.
Yeah.
Tell your dad, tell teachers.
Like I told him, I promise I would never say something like that.
So you haven't used Discord in a few months,
and
you're saying you didn't say anything like that?
No, the only thing I have is TikTok, but I just go around there and watch videos.
All right, well, fair enough.
What's your birthday?
He's just going to do a little report saying that
We talked.
we've done in reference to this, and that we talked, and you saying that you didn't say anything like that. And I got to take you at your word, and I hope you're being honest with me. I'm not saying you're lying, but it's
a serious thing. Really.
It's not unusual for people to lie to police. How's school going?
Oh, it's going good here.
About ready to get done with it?
I actually already finished, yeah.
Oh, you did?
Yeah.
When was your last day?
Let's say Sunday, so Friday.
Friday? What grade you going into? 8th grade, almost high school, man.
Yeah.
The last 4 years, really, the last 4 years is what matters.
Yeah, so I'm trying to, I'm just focusing on
Get them good grades, man. It'll set you up for the rest of
Yeah, so look, you all are welcome any time. We take it like dead serious around here, and I just want to make sure that I'd even feel better if you do find out what or where. Like, can somebody let us know?
Sure.
He's going to be full of anxiety until this kid's resolved. I can tell you that right now.
I've never really said something.
Yeah.
So did you switch schools when you moved from Traditions? Where were you going before?
West Jackson.
West Jackson Middle? Okay. Is things a lot better now?
Oh, yes, sir.
Okay. That's good.
Let me grab you one. Can I walk through your grass? I'm going to grab a car real quick.
Yeah, it's all good.
Are you getting bullied over there at West Jackson Middle?
That's the thing. I wasn't back there.
Oh,
I
yeah.
wasn't getting
Now, look, be honest with him about that
yeah.
now in middle school. I told him you were now, and that's
Getting switched out halfway through the school year? Being the new guy?
Yeah, I'm doing that for a while. We moved like 6 times already. So.
Well, my dad was a logger and grew up in the military. We moved a lot when I was a kid.
Yeah. Well, at the past schools, surprisingly, I had friends. Like, I didn't even necessarily have a reason that I would say that or anything.
Yeah. Well, there's always somebody you can talk to if you need to.
Yeah.
School resource counselors.
Yeah, and I do talk to them. Yeah, I talk to the counselor quite often.
Okay.
Let her update her on, just how I'm watching and stuff like that.
Yeah, start looking out and making goals for yourself.
Yeah, I'll do that.
You interested in anything?
I want to be a philosopher. I want to grow up.
A what?
A philosopher.
A philosopher.
Yeah.
All right, still with us, trial attorneys David Bruno and Nicole Branecki. David, I want to start with you. In watching that video, I want folks to know about a couple of months later, after the cops come to the house, the father buys him the gun that's used in the shooting. All right? So let's just say that. But here's what I see when I look at the video. I want to get your impressions. Is a serious dad, serious about outdoor lifestyles, serious about guns. And he says to the police he's teaching his son the seriousness and safety and all that goes along with guns, and I'm buying it. I'm buying it. What do you make of this, especially in light of the fact that that father has now been charged with murder?
Yeah, I see it a little different, Michael. I mean, that is laxed right there. I mean, you hear him say the words, but he also says that they're not loaded, they're accessible. If this is true, he would never have him access them again. And then after that interaction, there is an FBI tip. He admits he was on Discord at some point, which is corroborating the tip a little bit. Doesn't say, it proves it. But with that being said, even after that, and I don't know how many times families could say that sheriff's officers are reporting to their house asking about some sort of threat to shoot a school, and then go and buy the gun that was used in the shooting. I cannot believe that. And if I were a family member of the ones that had died and I saw that, I would be absolutely upset hearing these words.
Yeah, a lot of our viewers upset as well. They think that interaction should certainly have been a red flag. But I'll say something, Nicole, that I said a lot during the Crumbley trial. It's difficult for parents to see their child doing something like that. It is so extreme that you just don't see it coming. That's not to say there shouldn't be some sort of liability. We talked about this in the Crumbleys, civil versus criminal. But your thoughts on not only the idea of how parents see their children, but the fact that the law is now charging parents to do something about this problem with shooting schools.
There is right now, as you said, there is a lot of discussions regarding parents' liability in these types of scenarios. We've seen it in the Michigan case. We're seeing it here as well in the Georgia case. But there is, as always, there is in litigation so many factors that need to be considered. So for instance, the child's age, the child's maturity level, also the level of the parent's knowledge. And here I think that there's a lot to argue that the dad had a lot of knowledge of these threats, and also, but also so did the authorities. The authorities knew about that as well. The father knew about that as well. And this is a question that is very difficult to answer at this early stage. So I think that's very properly referred to a jury. And we shall see what happens.
Yeah, but as David said, a lot of people looking at that interaction as notice enough, and there's something that should have been done by the family. All right.
Liability in these.
Thanks to Michael Ayala and his duo of experts. This is such a mess. I said right from the beginning that what after it went down and Colt was arrested, I just had this feeling this is going to be the Crumbleys all over again. Not soon after that I said that, bam, Dad Colin gets arrested, and now they're still wondering now if Mom knew anything about it. In fact, they're saying that both of Gray's parents had expressed concerns over their son's struggles. His father told authorities he was bullied at school, and his mother called the school roughly half an hour before the shooting occurred to warn staff of an extreme emergency, urging the counselor to check on her son. If that was the case, then my only question would be, why didn't Mom go to the school herself? Why didn't Mom go to the school herself and check on her son before any kind of shooting started? Stop him before it starts, right? Just an idea. Next up, Kimberly Singler. She's an American woman accused of killing her two children and two of her kids in Colorado, and told the surviving 11-year-old daughter God made her do it. God made her do it. Yeah. And 50 cents will get me a cup of coffee at Starbucks, right? An American woman accused of killing her 2 youngest children in Colorado last December told her 11-year-old daughter, who survived the attack, that God made her do it, a prosecutor said in a London court. The girl begged for her life after Kimberly Singler stabbed her and, despite the child's plea for mercy, cut her again, prosecutor Joel Smith said. The harrowing details came as Singler fights extradition to the United States in Westminster Magistrates Court. Singler denies attacking her children and is concerned for her daughter's statement to police was coerced, according to defense attorney Edward Fitzgerald. Singler should not be extradited from the United Kingdom because if she's convicted of first-degree murder in the United States in the state of Colorado, where the killings took place, she would face life without parole, a sentence that violates European human rights law, Fitzgerald argued on Friday. 36-year-old Singler is charged with 2 counts of first-degree murder in the shooting and stabbings of her 9-year-old daughter and 7-year-old son, and 1 count of attempted murder for harming her older daughter. She faces additional counts because the children were under the age of 12, along with an additional count of assault. Fitzgerald, who represented WikiLeaks founder Julian Assange in his long extradition fight to face espionage charges in the United States, argued that life without parole would be inhuman because it offers no prospect for release even if she's rehabilitated. Hello, that's the idea of life, ... without the possibility of parole. You are spending the rest of your natural life in prison. And who's to blame for all that? Despite the possibility that the sentence could be commuted by a Colorado governor, that would amount to political suicide, Fitzgerald said, citing experts who said it had not been done before. In Colorado, as a matter of history and political reality, there is no realistic prospect of release. Whatever progress is made, Fitzgerald said, no matter how bad the crime, there should be some opportunity of release. As Fitzgerald was winding up his argument, Smith rose to say he had become aware of evidence that former Colorado Governor John Hickenlooper had commuted the first-degree murder sentences of 6 men in 2018. Judge John Zanni then adjourned a 3-day hearing in light of potentially important information until December 2nd to allow lawyers to confirm a news report about the commutations and provide further arguments. Singler, who is in custody, was in the dock and only spoke to acknowledge that she understood why the hearing was being continued. The hearing was primarily focused on the legal issues surrounding extradition. On Wednesday, Smith outlined new deals in his opening statement. He said that at the time of the killings, Singler was in a custody battle with her ex-husband, Kevin Wentz. He had been awarded more time with the children, and she had been ordered to turn them over to him from December 16th to 31st, but had not done so. Shortly after midnight on December 19th, Singler made an emergency call to Colorado Springs police. Officers found the 2 youngest children, 7-year-old Aiden Wentz and 9-year-old Ileana Ellie Wentz, dead in bed together in their apartment. They had been shot and stabbed, Smith said. Singler's older daughter, identified in court papers only by her initials MW, was seriously wounded. Singler, who had superficial knife wounds, was initially considered a victim in what was reported as a burglary, police said. She would later tell police that she had woken on December 18th feeling weird and woozy and that the children had seemed drowsy as well. Smith said she said that she suspected her former partner, the children's father, of killing them or organizing to have them killed. She said that a dark figure had entered her apartment and that she had fainted. Singler's ex-husband, however, had a solid alibi, Smith said. He was driving a truck that had GPS tracking. The daughter, who survived her attack, initially told police that a man entered their home from the patio and attacked them. But after recovering from her wounds and being transferred to a foster home, she told a caretaker that her mother was responsible and had asked her to lie to police. The girl said Singler gave the children milk with a powdery medicine to drink and told them to close their eyes as she guided them into one of the children's bedrooms, Smith said. The defendant told her that God was telling her to do it and that the children's father would take them away, Smith said. DNA tests on the weapons found a mixture of blood matching the children and their mother. An empty bottle of sleeping pills was also found in the house. After her daughter changed her story, police sought to arrest Singler on December 26th in Colorado, but she had fled abroad. She was caught in London's posh Chelsea neighborhood 4 days later. Now, I don't know what to say to anybody else, but this is enough to make my blood boil. She's probably one of the worst parents I've ever covered in the 2+ years of doing Bethea'S Byte Reloaded. And I've covered a number of them. Tracy Ferreter, Tim Ferreter, her husband, Susan Smith, we'll talk about a little bit later. And that one goes all the way back to when I was just about to graduate high school. I can't even come up with names to put Kimberly Singler at the top of that list. And then on top of it, not only does she commit this heinous act, she says God was telling her to do it. First of all, before I end this out, let me say this. If Kimberly Singler believed that Almighty God was telling her to shoot and stab her 2 youngest children so her ex-husband is unable to get custody, and you believe that, I personally have a bridge I want to sell you for cheap. Great view. Okay. Next. Angel Voss is facing up to 24 years in prison for lying to federal authorities during the investigation of Brittany Drexel's murder. Yep, she pled guilty to lying to FBI. The girlfriend of a man serving a life sentence for the sexual assault and murder of a 17-year-old Brittany Drexel has pleaded guilty to lying to federal investigators. In March, Angel Voss was charged with 3 counts of making false statements to federal investigators. Voss was dating Raymond Moody when he killed Drexel in 2009. The charges accused Voss of lying to investigators in 2022, around the time Moody turned himself into authorities and confessed to Drexel's death. On last Monday, the FBI announced that Voss pleaded guilty to a 3-count indictment. She's facing up to 24 years in federal prison. The sentencing date has not been set. Moody, who led authorities to Drexel's body, said the night the teen was killed, he offered her marijuana and she voluntarily went to his campsite with him. That's according to the Associated Press. He claimed Voss was with him when he picked Drexel up. But after she left, Moody killed Drexel when she refused to have relations with him. Voss lied about 3 factors when telling investigators about the night Drexel disappeared, including her whereabouts after leaving Moody and Drexel. Authorities said Voss also took Drexel's cell phone and disposed of it, and lied when she said Drexel voluntarily joined them to consume marijuana and cocaine, when in fact Drexel was abducted under false pretenses. Yeah, she's facing up to 24 years in prison, but the question really is, how long will she face? I mean, you lied to federal agents in regard to Brittany Drexel's death, and you're saying you confess to it now. And you want to plead guilty to it now, but you had no problem lying before? Sorry, Angel, but you're only an angel by name. I like to see her get the full 24. But it's a whole heck of a lot better than what her boyfriend is being sentenced to now. He's spending the rest of his life behind bars, even though he said, "Yeah, I did it." Next up, in a trial that is actually in progress right now. This is day 1. Mississippi versus Carly Gregg. The judge says note exceptions. Discovery violations leave Carly Gregg's defense in limbo. At least one defense witness will not be allowed to testify at Carly Gregg's trial after the judge found willful discovery violations. Oh boy. So the defense is already behind the 8 ball. Let's go to coverage by Court TV right.
Now for what's tipping the scales of justice at a motions hearing for teen murder defendant Carly Gregg on Wednesday. Prosecutors cited several discovery violations by the defense. Gregg is charged with first-degree murder of her mother and attempted murder of her stepfather. Prosecutors revealed that they haven't received any witness lists from the defense and have only gotten minimal information. They asked the judge to bar the defense team from introducing witnesses and evidence disclosed after the August 20th deadline.
Most of the witnesses that we have are witnesses that we have gotten from the state.
Okay, the Supreme Court's also dealt with that. There is no exception under the defendant's requirement to disclose witnesses.
Now, the judge ruled that at least one defense witness would not be allowed at trial because of the discovery violations and limited what others could testify to. So will these discovery violations tip the scales against Carly Gregg? Let's talk about it. Criminal defense attorney, former prosecutor Franz Borchardt, still with us. Oh, Franz, it seemed like The judge was a little frustrated with the defense team, saying, you guys are seasoned lawyers. What is going on? You've been doing this for 20 years and you can't make a deadline? What are you thinking?
So the optics are they're torpedoing the case to give her what we call an ineffective assistance of counsel claim, Julie. So the viewers understand she's entitled to have effective representation. Effective, it doesn't mean Rolls Royce, but competent, effective, like doing their job. And when they don't do their quote unquote job and it adversely affects her, it gives her appellate issues later on. This is a case that already has some pretty significant issues that are going to be looked at on appeal as to her being tried as an adult, etc. So I'm not saying they intentionally torpedoed the defense. What I'm saying is, how hard is it to submit a list? If your witnesses are all the state's witnesses, how hard is it to just Xerox copy a copy of the state's witnesses and say, you know what, Judge, here's our list. It's timely. Keep it moving. So it just looks bad.
Yeah, it sure does, Franz. And I appreciate you saying that, because you have to wonder, these are lawyers that know better, so why aren't they doing better? You're right. Is it to be ineffective, perhaps, to give her some post-conviction relief if she's convicted? Franz, one of the big issues that came up yesterday had to do with a urine test. So apparently Carly Gregg smokes marijuana, according to the prosecution, and she failed her urine test when she got into the detention center right after she was arrested. Let's listen to what both sides are saying, because of course the defense wants to keep the test out.
The state is not attempting to use this screen for quantification, rather for presumption. As pointed out in our response, the defendant has admitted during particular evaluations and through other witnesses that she did in fact use marijuana. She has said that she used it during her assessment with Region 8 as well. She says that she smoked it. This happened on the 19th. She says that she smoked it on the 18th at least.
What the state's wanting to do is take that test and then turn it into evidentiary purposes. They say, well, we just want to have it as like an identification kind of thing. Well, no, they're wanting to, in the reports, they're going in and trying to say whether or not she's under the influence at the time based upon that test, which is an invalid test.
So the judge decided the test is going to only be admitted as part of the prosecution's rebuttal case if we see Carly Gregg pursue an insanity defense. Franz, what do you think? Is that the right ruling?
I think it is for now the right ruling. So the biggest issue is the evidence offered relevant? And if it is relevant, which I think there is some relevancy here, is it more prejudicial than probative? That's the balancing test. And I think there's some prejudice in here. However, a lot of things happen during the course of a trial. A lot of things happen and a lot of things don't happen. And if there's certain evidence that doesn't come out during the course of the trial and all of a sudden it's not really relevant whether or not she presumptively tested positive, and that's what we're talking about, a presumptive urine test. Well, if that's the case, then it may not come in at all. So I think it's the right decision for now, but that decision may modify and change after the close of the defense.
Franz, thank you so much for that great analysis from you, as always. Thank you kindly. We'll let you get on with your day. And stay with us in our next hour for more discussions as court has begun in Florida. We're going to be taking you live there for the Buried in the Backyard murder trial when Court TV Live begins in just a moment. Right now, thank you for watching Opening Statements. So we're heading to the top of the hour. Remember, you can always watch or share the episodes if you like them. We're going to be right back on the other side, live next.
Huge thank you and shout out to Julie Grant, and I don't know that attorney's name. We as Court TV fans know him simply as Franz. Thanks, Franz, for your insight on the defense's case. The Carly Gregg's defense team is already behind the 8 ball as far as I'm concerned. Key deadlines are missed. There's some witnesses are unable to testify because of discovery violations. Now they're really gonna have to work with. They're really gonna have to work with what they have at this point. And as I mentioned earlier, that trial has already started. The jury has been seated, and next up, already if they haven't done so, is opening statements from both Carly Gregg's defense team as well as the prosecution, and I will be sure to give you all the details as to what's going on in that case, in what Court TV is calling the Deadly Daughter murder trial. Speaking of cases speaking of another case that we're covering here, Richard Allen's defense filed a motion last week announcing their plans to appeal the order that blocks them from presenting the Odinism theory. I'm going to go ahead. I'm going to put up the oh, this will be quick, but still, I'm going to go ahead and put up the disclaimer. It's only going to be a minute-long video, but the disclaimer's going up nonetheless. I'm going to mute, and I'm going to take you to Michael Ayala and Judge Ashley Wilcott as they briefly cover this ruling regarding.
We have new developments in the Delphi murders case in Indiana. The attorneys for defendant Richard Allen filed an interlocutory appeal of the judge's ruling that blocks them from presenting the Odinist theory in court. Last week, Judge Grant Gull ruled the defense failed to produce admissible evidence demonstrating a link between Odinism and the murders.
Now, in its filing yesterday, the defense said the order denied Allen's right to present a defense in violation of the Sixth Amendment to the U.S. Constitution. The defense is also appealing a decision to allow all of Allen's alleged confessions evidence jury, saying the judge's ruling denied Allen his 5th, 6th, and 14th Amendment rights under the U.S. Constitution, as well as his constitutional rights under the Indiana Constitution.
We are told that Judge Gull would need to sign off on the appeals for them to move forward. Scripps News Indianapolis is reporting that if the appeals move forward, it could delay the trial, which is scheduled to begin on October 14th.
Allen is accused of killing teenage friends Abby Williams and Libby German back in 2017.
Again, thank Judge Ashley Wilcott and Michael Ayala, Court TV. You can catch them in the afternoons. As it stated, Allen's attorneys filed a motion alerting the court of their plan to appeal. According to the motion, the defense says the order denies Allen the right to present a defense, and depending on the decision by the Indiana Court of Appeals, the scheduled trial start date of October 14th could be delayed. So we'll have to wait. We're just going to keep an eye on that one as well, and we'll see how that will stand. Next up, the case against the teenager accused of killing Lily Peters will stay in an adult court. The case against a Wisconsin teenager accused of killing a 10-year-old girl he allegedly lured into the woods will remain in adult court. That's according to a state appeals court. Prosecutors charged the teenager, identified in court documents only as CTPB, as an adult with first-degree intentional homicide and 2 counts of sexual assault in connection with the death of Ileana Lily Peters. Investigators say Peters was riding her bike home from her aunt's house in Chippewa Falls on April 24, 2022. when the teenager, who was 14 at the time, persuaded her to leave a trail and explore the surrounding woods with him. The girl's body was discovered the next day. An autopsy determined she had been beaten, strangled, and sexually assaulted. The teenager's attorneys, Michael Cohen and Alicia Linsmeyer, asked Chippewa County Circuit Judge Stephen Gibbs last year to move the case into juvenile court, where proceedings are secret. They argued that the teenager would not receive the mental health treatment he needs in the adult criminal justice system. The judge refused, finding earlier this year that such a move would depreciate the seriousness of the offenses. The 3rd District Court of Appeals upheld that decision on last Tuesday, finding that Gibbs properly exercised his discretion. The appellate court noted that Gibbs detailed the severity of Peters' injuries, that the teenager told investigators that he attacked her, that he lured her into the woods, and that the crime was premeditated. A message left at Cohen's office wasn't immediately returned. Honestly, guys, I agree with the judge. The defendant pretty much admitted to the whole thing. What else are you gonna do? What else can you do? You commit an adult crime. You face adult charges. Moving the case to juvenile court is gonna do nobody no good here. Especially with a grieving family who wants nothing more than to seek justice for the girl that was taken away from them. Next up, a little bit of an update in the Courtney Clenny case. But I believe this one involves more of her parents. OnlyFans model Courtney Clenny's parents accused the state of digital burglary for holding on to evidence in a dismissed case. Oh boy. No, I won't play that video. Oh, that's a little too long. But I'll go ahead with the article. An OnlyFans model accused of killing her boyfriend was in court on Wednesday with her parents in a fight to have evidence returned. Courtney Clenny is charged with second-degree murder for the stabbing death of Christian Obumsely. Clenny has claimed she acted in self-defense when she killed him. As part of their investigation, detectives obtained a search warrant for not only Courtney's accounts, but also those of her parents, Kim and Deborah Clenny. Based on what they found, prosecutors then filed computer crimes charges against the entire family. But those charges heavily relied on messages protected by attorney-client privilege, forcing prosecutors to drop the charges after a judge ruled the evidence was inadmissible. Despite the charges being dropped in July, the hard drives seized by investigators have remained in the custody of the state. They were seized under a search warrant in Courtney's murder case, but were ordered to be held separately in a vault after the discovery of privileged information. Kim and Deborah are fighting to have the evidence returned or destroyed and accuse prosecutors of digital burglary. In their final pleadings, the state used the phrase digital burglary when describing the computer offense with which they charged the Clennys and ultimately abandoned. We disagree with the phrase's applicability to that charge, but prefer it for use here. The search of the petitioner's iCloud was a digital burglary unsupported by probable cause of anything. It is, however, indicative of the state of Florida, particularly the Miami-Dade State's Attorney's Office's overly zealous and seemingly personal persecution of this family. At the hearing, prosecutors suggested that the data seized doesn't qualify as the Clinty's property because it was created and received from Apple. Prosecutors also argued that digital evidence found during their investigation, which included surreptitious recordings and a recording of Courtney telling Obumsley to enjoy the hospital after splitting his lip, is critical to their case. They also said Courtney's accounts were combined with her mother's and were actively being assessed months after her arrest. The judge ruled the files would not be released to the Clintys and would instead be given to prosecutors who will be able to review the contents for information relevant to the murder case. Courtney's attorneys have also asked the judge to consider releasing her since she has been in custody since August 10, 2022. The judge said she would consider that motion at a later date. So it looks to me, guys, that the parents got more problems than they know what to deal with, and they're trying to get all that evidence back off their computer. Now, whatever was on it could be used as evidence in this case against Courtney. Keep an eye on this. Next up, a teen once charged in his father's death is now accused of killing his mother. Colin Griffith, accused of fatally stabbing his mother. Authorities said he once faced charges for the death of his father. All right. Let me go ahead once again. Here's the. Let me first off. Let me hit the trigger warning first. Everything you're gonna see in this may be triggering to you. Viewer discretion is strongly advised. Now, here's the copyright disclaimer. I'm gonna get out the shot and I'm gonna mute. And the next voices you'll hear will be coming from Court TV, your front row seat.
It's not just a singular murder, but as we got into the investigation, we found that about a year and a half, maybe a year and 9 months earlier, he murdered his father.
This morning, we're spotlighting the story of a Florida teenager who's accused of fatally stabbing his mother just 18 months after fatally shooting his father. Investigators are calling this kid a psychopath. This is him, 17-year-old Colin Griffith. Investigators believe that an altercation outside of his grandma's home is what led to his mother's stabbing last week. The sheriff is calling this simply a cold-blooded murder. The latest deadly encounter comes less than 2 years after he was arrested for shooting and killing his father. Scripps News, Cape Coral, has more.
I'm Fox 4's Anvar Vruziev, and I'm in Port Charlotte, where this morning I'm bringing you a disturbing story of a teen who killed his father, and now he's accused of killing his mother in another county far from this home where she lived. Neighbors say this is Colin and this is 39-year-old Catherine Griffith. Wednesday afternoon, Polk County deputies said Colin Griffith used this knife to murder his mother in Auburndale Sunday night. Initially, the teen told deputies his mother had lunged at him with the knife.
Colin said, "I've had a very, very long fight with Mom, and she fell on a knife and she's bleeding from the neck."
However, Sheriff Grady said an investigation revealed the 17-year-old's claim wasn't true, and the detectives charged him with first-degree murder, kidnapping, and violation of a no-contact order. Even more concerning, Sheriff Judd said Griffith has claimed self-defense before, after he killed his father in Oklahoma. The charges were eventually dropped, something the sheriff didn't agree with.
Had Oklahoma been able to act, Catherine would be alive and well today.
Neighbors I spoke with Wednesday afternoon said they had seen police at Catherine Griffith's home regularly. One neighbor claimed Griffith left an abusive husband and moved to Florida, that she had 2 sons and worked as an English teacher. That neighbor also shared texts she claimed were exchanged with the victim shortly before her death. The text shows someone claiming to be Catherine talking about how she was reporting her son as a runaway to Charlotte County deputies because he was in violation of probation. The text indicated that the suspect refused to listen to local detectives, and the texter said, quote, "I'm going to drive to get him, and if he doesn't get in the car, then Polk County can deal with him." Now, we've since called Polk County investigators about these texts as potential evidence in their case. We've also reached out to the Charlotte County Sheriff's Office about previous dealings with Colin, who Sheriff Judd says wants to try as an adult. In Port Charlotte, Anvar Ruziev, Fox 4.
Let's talk more about this very disturbing young man and these 2 cases that he's involved with. Let's bring back in law enforcement expert Sonny Slaughter and retired criminal defense attorney Kirk Nurmi. After this altercation with his mother, we understand this kid runs to his grandma's home, which is over an hour away, and some things led up that led to the stabbing. I want you to both take a listen, please, to the Sheriff Grady Judd outlining what investigators say they believe occurred.
At about 4:30, witnesses and neighbors see Colin and Mom arguing outside, and Colin grabs his mother by the hair and drags her into the house. Just about 2 hours later, that's when we receive a 911 call where Colin said, "I've had a very, very long fight with Mom, and she fell on a knife and she's bleeding from the neck." Our investigation clearly and unequivocally shows that that circumstance did not occur like that.
Fell on a knife. Sonny Slaughter, I want to begin with you, please. You've heard a lot throughout your many years of service. Let's talk about this one here. Your thoughts, please.
It is unfortunate that parents and mothers, we have such faith sometimes in our children and in our offspring, and we do whatever we can to help them. But there's also a reality to the threat that some children can pose and do pose, as this young man did to his parents. And I do not think that with all of the mother's efforts that she came to that realization at a time when she should have to save her own life. This child is definitely psychopathic. He is dangerous. She knew he was dangerous and she still tried to help him, and she lost her life because of this. As parents, we have to come to a reality even when it involves our own children.
Yes, said Sonny. The sheriff said that after he came to live with his mother, he attacked her multiple times. In one DV case, he actually stomped on her, according to the sheriff's department. He was briefly held for some mental health services, released back with her then. The sheriff addressed this kid's appearance during that press conference. I want to play that for you both now.
It's important to understand, when you look at this, you see a kid. When I look at him, I see a psychopath. I see totally erratic behavior, to the point that he's already, at 17 years of age, shot and killed his father and got away with it, and stabbed his mother in the neck so hard that the knife went all the way through and was to the back of her neck, and she died there. He's being charged with first-degree murder, obviously, and we're asking the state attorney's office, it's their decision, but our state attorney's office is the greatest, to prosecute him as an adult.
A great request there. Kirk Nurmi, your thoughts on whether that request is going to be granted? Do you think he will be tried as an adult?
Yeah, certainly, Julie, I do. I mean, at 17, the severity of the crime, the things that judges take a look at when they're considering that includes the severity of the crime, their age, what have you, right? We saw that. We talked about Carly Gregg earlier. 13, the judge decided the severity of the crime was enough to warrant her being charged in adult court. And here, the circumstances around this man, and it breaks my heart when you say, you know, he was briefly held for mental health services. I wonder how brief, and I wonder what those services are. Considering, and we talk about Miss Gregg, we talked about 14-year-old school shooter a few weeks ago. The need for these mental health services, this is the part that breaks my heart, Julie, is they can't be brief and they can't be services in name only. The interventions need to be severe if we really want to stop these kind of homicidal teenagers, whether it's with custody or what have you. But something needs to change, because as Sonny's right, so many times the parents will write it off, and unfortunately in this case that was to this mother's own demise.
You're exactly right, Kirk. Thank you for that. When I was researching what happened with Dad, because that really had me curious, how did this case get dropped? Apparently investigators had reported that this kid, or a psychopath, as Grady Judd calls him, the sheriff. Love that sheriff. He's a very good sheriff. We've seen him on cases before. And said that apparently the kid claimed that the shooting was in self-defense. And the investigators who worked that case in a different region, as we saw in the Scripps News report, they came to this was in Lincoln County, Oklahoma, was where his dad was shot. In Oklahoma, the investigators said they couldn't find anything that would disprove his claim. He claimed that he had to shoot his dad in self-defense, and now I'm wondering if those investigators may take another look at it. Sonny Slaughter, what do you think about that? Coupling it with the information we know about what happened with Mom, do you think they may crack open that case file?
I think it would be in their best interest to do that, to go back, review everything that they thought. And, a lot of times people are giving young people based on age, a way out, or, more weight towards their age than their behaviors. And that could have been what happened in this case. So I think they'll go back, look at that case, and if necessary, recharge or charge him accordingly if they find substantive evidence to back up any additional information and allegations they may come across.
Yes. Sonny and Kirk, thank you both for the great insight. We're going to leave it there for now, but this, of course, is a case we're going to continue following. It is just stomach turning.
Sorry about that, I got a little distracted. But I want to thank Julie Grant. I want to thank Sonny Slaughter, litigations expert, and L. Kirk Nurmi, the former criminal defense attorney who was once tasked with the defense of one Jodi Arias. Now, this case is really got me at a point. I'm thinking, good grief, what could have driven this kid to not only kill his dad, but then a couple of years later his mom? Or maybe I have that backwards. But still, she's doing what a mom's supposed to do, and he's gonna kill his mom for what? We'll find out what happens when what happens with this case. And I will also a big shout out to Polk County Sheriff Grady Judd. This is the kind of officer we need a lot more of. Next up, panel of judges says that the DA who oversaw the case against Barry Morphew should be disbarred. Colorado state regulators ruled that a district attorney who brought criminal charges that were ultimately dismissed against the man accused of killing his missing wife should no longer be allowed to work as a lawyer, finding that her management of a high-profile case resulted in the prosecution running aground. Ouch. The panel issued a 2-1 ruling to disbar 11th District Attorney Linda Stanley, who prosecuted Barry Morphew in the death of his wife Suzanne Morphew, who was reported missing on Mother's Day in 2020. Barry Morphew had posted a video on social media pleading for his wife's return soon after she vanished. His arrest a year later prompted widespread media attention. A representative of Stanley's office, who did not want to provide her name, said that Stanley had no comment. Stanley's lawyer, former prosecutor Stephen Jensen, said he and Stanley were considering whether to appeal the ruling to the Colorado Supreme Court, noting that one dissenting member of the panel said Stanley should be suspended rather than be disbarred. As a rural district attorney not accustomed to handling high-profile cases, Stanley did not have as many resources as prosecutors in urban areas and also had difficulty finding attorneys to work on the case, Jensen said. She was trying to conduct herself in appropriate fashion under the difficult circumstances she was presented with, he said, echoing the argument he made before the panel when it held a 2-week hearing on Stanley's conduct in June. A final order that would prevent Stanley from working as a lawyer is normally issued 35 days after a ruling, but the opinion said that Stanley can ask for a delay to allow her appeal. Stanley dropped the charges in Suzanne Morphew's death in April 2022 after a judge barred prosecutors from calling key witnesses for repeatedly failing to follow rules for turning over evidence to the defense. That included DNA from an unknown male found in Suzanne Morphew's SUV. The DNA corresponded with partial profiles found in 3 unsolved sexual assault cases. Lawyers for the office that oversees attorney conduct, the Office of Attorney Regulation Counsel, compared Stanley's conduct in the case at a June hearing to a ship's captain who didn't appear on the boat's bridge. The panel agreed, adopting that analogy. Respondent's absence at the helm during key phases of the prosecution, even when she was warned that it faced rough waters, led to a series of events that ended with the first-degree murder case running aground, it said in its opinion. The panel found that after prosecutors were barred from violating evidence rules, Stanley launched a groundless criminal investigation into the presiding judge in a failed attempt to have him removed from the case. After that probe failed to turn up anything, Stanley asked for the case against Morphew to be dropped, the panel said. It also found that Stanley made unethical statements about the Morphew case, including comparing it to the cases of people convicted of murder, even where no body was found, in a chat forum for the Profiling Evil True Crime podcast. Suzanne Morphew's remains were found in September 2023 in a remote area of central Colorado, more than 40 miles south of her home in the mountains near Salida, Colorado, as authorities were pursuing a different case. An autopsy report released in April labeled her death a homicide, but said she died by undetermined means. A cocktail of drugs that were used to tranquilize wildlife was found in one of the 49-year-old woman's bones, but there was no indication of trauma, the report said. The prosecutor for the part of Colorado where the body was found, the 12th Judicial District Attorney Ann Kelly, has said her office was assisting in the investigation. No new charges have been announced. The panel also found Stanley violated ethical rules for comments she made in a fatal child abuse case in which she told a reporter that a man accused of killing his girlfriend's 10-month-old child agreed to be a babysitter so he could get laid. Jensen said Stanley believed her comments to the reporter were off the record. Charges against the man and his girlfriend were dismissed because of Stanley's comments. In the Navy, they say loose lips sink ships. Biblically, they say this: death and life are in the power of the tongue. And in Linda Stanley's case, it was her mouth that got her in so much trouble that she may very well be disbarred from practicing law. It's all. Well, I don't care whether you're a prosecutor, a district attorney, or what have you. The bottom line is, be careful what comes out of your mouth. It can very well mean the difference between costing somebody's life, costing a defendant their life, or costing you your entire legal career. We're going to go back to Kelly Craft and Julia Janae as Karen Reed's attorneys filed a petition with the Supreme Judicial Court of Massachusetts asking for charges to be dismissed.
Welcome back to Court TV Live. We are following breaking news in the Karen Reed case. She has filed officially an appeal of the 2 charges against her, 2 of those 3, to the Massachusetts Supreme Judicial Court.
Reed's defense is asking the court to dismiss the second-degree murder and leaving the scene charges. Her defense says that 4 jurors told them the jury had unanimously agreed 2 not guilty verdicts on those charges. Reed's defense claims retrying Reed would violate double jeopardy protections.
And you'll remember that the jury came back hung on all counts against her, and then that was appealed to the trial judge, Judge Beverly Cannoni, and Judge Cannoni denied the motion to dismiss from the defense of those 2 charges. Now, her new trial is scheduled for January, so still on the books, but could this appeal delay things? Let's bring in criminal defense attorney Laurie, who is standing by. Laurie, what do you think about the impact of this appeal on the timing as we're marching towards this retrial in January of 2025?
Oh, well, it may slow it down, but we're hoping that the court, the appellate court will have a decision fairly quickly. I mean, the issue is very concise, and especially on the second-degree murder and also leaving a scene. If you've got 12 jurors or the jurors agreeing basically unanimously that she's not guilty, then that is a very good issue on appeal, and hopefully the Court of Appeal will agree with them and dismiss those counts. And it's important for that to be resolved before they move on to the next trial, right? And that's what I would think would happen here.
Laura, so in Judge Cannoni's motion, or the one when she said this is denied, so now they've appealed straight to the Supreme Judicial Court of Massachusetts. So what she said is this is not a situation of double jeopardy. The jurors did not acquit her on any of these charges. That's what she said in her ruling. And then she also said in her ruling that defense counsel did not have any objection to the court declaring a mistrial in her case. So that was her reasoning. When you take a look at her denial of defense counsel's motion, that was her reasoning. Now we have this next step here. From my perspective, I would assume that the Supreme Judicial Court of Massachusetts is going to fall in line with Judge Cannoni's decision. She was the one that was in that courtroom. Obviously, we'll have to see what the Supreme Judicial Court of Massachusetts decides. But what do you think of Judge Cannoni's reasoning there? And then now, as we go to this next step.
Look, I understand her reasoning, and obviously she ruled based on that. She's the court, she's the judge presiding over this case, and I'm not quite sure how the defense knows. I'm assuming they must have talked to the jurors. They reached out to them, and they were pulled, and they know that they were all in agreement as far as the acquittal. Unfortunately, as the court has said, that was not done in court. In fact, they asked for a mistrial. Look, it's a legal issue. It requires a lot of research. And it is possible that the higher court may agree and fall in line with the judge in this case. You never know. There may be something there. Otherwise, why would they bother? They're not trying to waste time here. They did their first trial, and it's definitely worth a shot. What if the court agrees with them on the issue?
If they do, that will change completely what happens at this retrial. I think it could even mean that these parties might start talking about how to move forward.
And basically, we're still in a wait and see kind of situation with that case. Hey, thanks to Julia Janae and Kelly Craft for coverage, and we're gonna keep an eye on this case. If those two charges get dismissed, she'll still have to answer one, and that trial will begin in January. Next up, a rideshare driver accused of sexually assaulting and murdering a passenger and dumping the body. Francisco Valadez allegedly confessed to murdering Shanti Dixon while he was trying to have relations with her after picking her up. An Uber driver in Indianapolis is accused of sexually assaulting and murdering a passenger and then dumping their body. 29-year-old Francisco Valadez was arrested and charged with murder the day after the body of 30-year-old Shanti Dixon was found outside a home on the city's southeast side. Dixon had been reported missing earlier in the day after her mother said she took an Uber home from work. Dixon was never heard from again. Investigators say that Valadez told them a number of different stories. First saying that when he dropped Dixon off, she was robbed by a man with a gun who shot her in the thigh. Eventually, police say Valadez admitted to shooting Dixon in the back of the head because she laughed at his small member, making him mad while he was trying to have relations with her. Valadez allegedly told officers that after he shot Dixon, he dragged her body behind a concrete barrier and tried to have relations with her body again. This is disgusting, Indianapolis Metro Police Chief Chris Bailey told Scripps News Indianapolis. It's disturbing. No one deserves to be treated this way in our community. When police talked to Valadez's mother, she confirmed that he carries a gun. I keep waiting for her to walk through that door, but I know she won't, Dixon's mother, Rose Dixon, told Scripps News Indianapolis. For people out there that's doing stuff like that man did to my child because you picked up a stripper at work and thought that no one would care, we do, and you can't do that. Don't let what happened to her diminish what she put out in the world. Valadez got himself hung up, and he knows it. He knows it. So he might as well get himself prepared because he's got to face these charges. He's got to face those charges, and he is definitely going to do a lot of hard time. Next up, Donna Adelson made her final pre-trial court appearance on last week. She's accused of conspiring in the death of her ex-son-in-law, Dan Markle. Donna Adelson appeared in court for a final pre-trial hearing ahead of her murder trial, which begins this week. Adelson is accused of conspiring with her son Charlie Adelson in the murder-for-hire plot that killed her ex-son-in-law Dan Markle. Before addressing a series of pre-trial motions, Judge Stephen Everett asked the prosecution whether they had extended a final plea offer. Assistant State Attorney Georgia Capelman announced the state is ready for trial and that they would not be offering Donna a plea agreement. After defense attorney Dan Roshbaum told the judge that he would not be making a counteroffer to the state, Donna stood and verbally stated under oath that she did not wish to make a counteroffer. Judge Everett then turned his attention to a list of outstanding motions such as the admissibility of evidence, including text messages between Donna and Charlie about media coverage of the murder, emails between Donna and her life coach, and texts between Donna and her daughter Wendy Adelson in the hours following Charlie's conviction. Wendy had been married to the victim prior to an acrimonious split. Tallahassee Police Sergeant Chris Corbett also testified about cell phone location data, and the judge also made a final ruling regarding a summary that's expected to be presented to the jury, not as evidence, but as a demonstrative aid. Donna is the fifth person to face charges in Markle's murder. Hitman Luis Rivera took a plea deal in 2016 and is serving a 19-year sentence. The other hitman, Sigfredo Garcia, was convicted in 2019. Garcia fired the gun, shooting Markle in the head twice. Catherine Magbanoa, who was the link between the Adelsons and the hitman, was convicted in 2022. And finally, Donna's periodontic son, Charlie Adelson, was convicted last year. Magbanoa was Charlie's ex-girlfriend. Magbanoa and Rivera, who are both cooperating witnesses in the case against Donna, were transferred to Leon County Jail in anticipation of their testimony. Charlie, who was listed as a witness for the prosecution, is expected to be transferred to the jail in the coming days. Jury selection is set to begin tomorrow, September 17th. And as I always promise, no matter what the case, Bethea'S Byte Reloaded is loaded for bear to cover this particular case. Now, this is a Court TV exclusive. As I mentioned before, Susan Smith is getting closer and closer to her parole eligibility date. Her ex-husband is going to have a sit-down with Court TV's Julie Grant to talk about what he would say to his ex-wife and whether he endorses her to be released from prison. So, again, I'm going to step out. I'm going to mute. I'm going to step out of the shot. I'll have the copyright disclaimer up right now. And here is that exclusive interview with Susan Smith's ex-husband from Court TV's.
This morning, we're spotlighting new reaction to Susan Smith's upcoming parole eligibility. The convicted killer became infamous after drowning her 2 young sons and trying to mislead the public into thinking that they had been kidnapped. Her husband at the time, David Smith, was by her side supporting her until she confessed. Now, David has been quiet for years about the case, but he recently gave us an exclusive interview talking about her upcoming parole hearing and how he's doing today.
I don't think I'm any more of a suspect than anyone in this case right now.
It's very painful to know that anyone would think that either of us had anything to do with this abduction of our children.
David, how do you feel about Susan wanting you to advocate for her prison release?
I think it's absurd. I can't comprehend that she even thinks that I would advocate for her.
When was the last time you talked to her?
It was about a month after she confessed and was arrested. I saw her at a prison in Colombia where she was being held at the time.
Mm-hmm. Has she tried to contact you then, since then, rather?
No, I've had no contact with Susan since that one time. We spoke for about an hour that day, and I haven't talked to her since.
David, do you plan to attend her parole hearing?
I absolutely do. I'm for sure going to be there.
Would you give us a little bit of a preview of what you plan to tell the board?
You know, at this time, I don't even know if I'm going to even write something formally on paper. I may just speak from the heart, but I just want them to know or remind them of what she did. Who were the victims in this case? Certainly not her. And to let them know that her only doing 30 years would be an injustice to Michael and Alex. She doesn't deserve to ever be free again.
David, would you tell us a little bit about your beautiful boys, Michael and Alex?
Well, Julie, unfortunately, I still do not have a lot of memories of Michael and Alex. Early on, I sought professional help, and all of them told me the same thing, that eventually the memories would come back. But at the time, it was my own system taking care of me and not letting me have any memories of them. It was protecting me. Well, here it is almost 30 years, and those memories haven't come back yet. I have bits and pieces, like giving them bath time with them and playing in the yard a little bit. And like Michael used to ride on the lawnmower with me, cutting grass, and he'd always go to sleep. So I have some snippets, snapshots of memory, but I don't have very many, unfortunately.
I want to say to my babies that your mama loves you so much.
David, how do you feel now about the cruel way in which Susan lied to you then?
After a lot of thinking and soul searching, I wish I had seen what other people were seeing at the time. But I just want to get Michael and Alex back. That was my main concern.
Tell us, have you forgiven Susan? And if so, why?
Yes, I've forgiven her. And again, that goes to my faith in God, and that's the way I was raised, that we have to forgive. But it sure doesn't take away the act of what she did. It doesn't make it any less. It doesn't make it any easier. But I have forgiven her for what she did.
Tell us, if Susan were here listening to this interview, what message would you have for her?
would just tell her that you have no idea of how much damage you have done to so many people. I would tell her that in my capabilities, I'm going to do everything in my power to make sure you stay behind bars.
This court stands adjourned.
I want to bring in the man who put away Susan Smith, attorney Tommy Pope. Tommy, would you walk us, please, through the legal process? What's going to happen next in this quest for parole?
So what's happened, and you and I have discussed this before, the jury didn't know that life didn't mean life, but now that there's been 30 years, because they did find the aggravating circumstances of killing two underage children, killing two or more at one time. So she's now eligible. There'll be a hearing probably October. David and I are still trying to coordinate with Solicitor Brackett on the dates and, all of that. And then basically it's kind of a mini hearing. They hear aggravation and mitigation. They'll hear, what David's got to say. I want to tell them how the jury believed that she was going to serve the rest of her natural life. I'm with David. We knew it was going to be an uphill battle, particularly with the union jury, but we try to respect their decision. We just wish they'd been armed with all the knowledge, because I remember jurors saying, she would sit and think about Michael and Alex, where her conduct's proven she hadn't done that. And she's been more worried, and I don't think I misspeaking here in front of David, she's always been more worried about Susan than she is anybody else. And that's been the case throughout.
Right, Tommy. And she has had a pretty bad prison record as far as I'm aware, hasn't she, Tommy, with misconduct with guards, and I believe drug use has also been reported. Is that correct?
She has had, I think, like we discussed before, I've seen much worse. I've seen them killing people in prison, but her behavior tells us that contrary to what that jury was thinking, which was you'll be remorseful, you'll think about Michael and Alex, Susan thinks about how things affect Susan.
Whoever has them, I pray every day that you're taking care of them, and know that we will do anything we will to help you to get them home back to us.
And David, I want to ask you now about what your life is like. I understand you have your wife, Tiffany, with you that you'd like to introduce to us. Would you bring her in, please?
I sure will. This is Tiffany, my wife.
And you have children together, right?
We do. We have a daughter together, and then I have a son by someone else.
Our daughter is 23, so we have the empty nest going on. So we spend a lot of time, just work, and then we come home and he cooks supper. He does a lot of the cooking. He helps me out a lot. I would try and push him to get out of bed and go do things, and he just wanted to sleep a lot. I call those the dark years. But, I just, over the years, I would try to push him to do things, to try to get his spirits up and get him out of the house, or, just to do different things. And then, as the years have gone by, things have gotten easier, and, he doesn't have as many dark days anymore. So, life is really good.
And I want to thank David and Tiffany Smith and attorney Tommy Pope. And you can watch even more of that interview. My full uncut conversation with David Smith and his wife will be posted to Court TV's members only channel. So just click to join if you haven't already.
I want to thank Julie Grant for doing such a great job with that interview, and I want to shout out to David Smith and his wife Tiffany for the burden that they've been bearing, knowing that Susan Smith could be up for parole in the next couple of months. I followed that particular case as a kid, just getting out of high school, and When I first heard that the kids were declared missing, the first thing I did was start praying that those kids will be found alive. Then I heard her first lie, the first huge lie, that it was a black man who carjacked her with the kids inside. Then the truth came out. There was no black man involved in this. She drowned those boys. And why? She wanted the happily ever after. The happily ever after she didn't get with David. She found the guy she wanted to be with, but the guy didn't want children. So she decided to get rid of the children so she can have that happily ever after. One small, minute detail to that, Susan Smith. It didn't work, and it ends up with you spending the last 30 years behind bars, and could very well mean more. But hey, wise man once said, "Don't do the crime if you can't do the time." And I'm in total agreement with your ex-husband David. 30 years, not long enough. You should stay behind bars, never to see the light of day again. Okay, I'm about to get these last few stories and I'm gonna get up out of here. First of all, we're gonna go to this past Friday. We had a verdict watch in the Buried in the Backyard murder trial, aka the My Daughter Did It murder trial. All right, Laurie. Let me I'll break it down for you. Laurie Shaver was charged with second-degree murder in the November 2015 fatal shooting of her husband Michael Shaver. Her daughter, at some point, made the admission that she shot him. Did a jury believe her? The verdict is in. So I'm going to leave you in the hands not only of the judge, but I'm going to leave you in the hands of my main man 50 Grand, already on his show Closing Arguments. I'm going to leave you with Vinnie Politan, ladies and gentlemen. Let's see what the verdict.
We've got some fast breaking news, folks. Look at this. The tie is a total mess. We've got a verdict inside the courtroom. Do we have Matt Johnson on the line, or is he going inside the courtroom? He's going in the courtroom. Do we have a video feed of what's happening inside? There it is. Do we have audio from inside the courtroom? We do have audio. She's standing. That tells me they're waiting for either the judge or the jury to enter the courtroom.
The jury have returned. And who is the foreperson? Please stand. Okay. Has the jury reached a verdict?
Yes.
Is it unanimous?
Yes.
Please hand the verdict forms to Madam Bailiff. Thank you. All right.
right, after having reviewed both verdict forms, the court finds that there are no errors or omissions in the filling out of the verdict forms. Madam Clerk, please publish the verdict.
In the Circuit Court of the 5th Judicial Circuit of the State of Florida in and for Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361. Verdict as to count 1. We, the jury, find as follows as to count 1 of the charge. The defendant is guilty of second-degree murder. Was the defendant in actual possession of a firearm? Yes. Did the defendant discharge a firearm? Yes. Did the discharge cause great bodily harm? Yes. So say we all, dated this 13th day of September. Verdict as to count 2. We, the jury, find as follows as to count 2 of the charge. The defendant is not guilty. So say we all, dated this 13th.
Does counsel for either the state or the defendant wish to have the jury polled?
Defense does, Judge.
All right, Madam Clerk, please poll each juror. Of this case, I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from your attorneys, or elsewhere. From the attorneys or elsewhere, it will be up to you to decide whether to preserve your privacy as a juror. Thank you so much for your time and attention and patience this week. Our system of justice would not work without good people such as yourselves. You are excused from further jury service. Thank you and have a nice night.
There you have it, folks. Laurie Shaver convicted in little less than 4 hours in the death of her estranged husband, whose body was found buried in the backyard. After being found guilty, Judge Carrie Rader remanded Laurie to the custody of the Lake County Sheriff's Office. Sentencing is tentatively scheduled for November 25th, pending completion of a pre-sentence investigation. Michael Shaver's body was found March of 2018, 3 feet below ground under a concrete slab and fire pit that Laurie installed in the backyard 2 years prior. She was arrested and charged with second-degree murder and accessory after the fact on September 2020. So there you go. That's one step toward justice. November 25th, we'll find out what the next step is. How long will she end up serving behind bars? Next up, one of my favorite country singers, Darius Rucker. The judge and prosecutors reportedly cited Darius Rucker's good character in their recommendation to drop 2 charges of possession. Musician Darius Rucker was reportedly sentenced to 11 months and 29 days of probation in his drug possession case. Earlier this year, Rucker was booked into the Williamson County Jail on 2 counts of simple possession and violation of registration. Rucker appeared in court and pleaded no contest to a single charge of simple possession. The other 2 charges were dropped as part of a plea agreement, according to the Tennessean. The Williamson County District Attorney's Office reportedly cited Rucker's good character when recommending the other charges be dropped. As you all know, Rucker rose to fame as the frontman of Hootie and the Blowfish back in the 90s. According to the band's website, they met while attending the University of South Carolina in Columbia in the late 1980s. Some of their greatest hits include a couple of my favorites: Let Her Cry, Only Want to Be With You, and Hold My Hand. Separately, Rucker has released multiple country albums and was inducted into the Grand Ole Opry in 2012. I really hope that that this move shows his good character, and he continues to show that good character moving forward. In another piece of celebrity news, Justin Timberlake enters his plea to resolve his DWI case. Justin Timberlake has a year to complete 25 hours of community service at a non-profit of his choosing as part of his sentence for driving while impaired, a traffic violation to which he pled guilty on this past Friday in a deal with New York prosecutors. Pop star was arrested in the morning of June 18, 2024 in downtown Sag Harbor, a seaside village in eastern Long Island's Tony Hamptons area, for driving his BMW through a stop sign and straying from his lane. He was charged with driving while intoxicated, a misdemeanor offense that carries possible jail time. Timberlake pleaded not guilty twice because of a clerical error that led Suffolk County prosecutors to refile the charge. Flanked by security guards and dressed in a gray cardigan, pleated chinos, and what appeared to be a double-strand pearl necklace, Timberlake waded through a throng of reporters Friday morning outside of Sag Harbor's historic municipal building. In exchange for his guilty plea to the reduced charge of impaired driving, Timberlake agreed to pay $760, have his license suspended in New York State for 90 days, and deliver a public safety announcement outside the courthouse immediately after the hearing. So what I'm going to do with that is I'm going to go ahead and hit the copyright disclaimer, mute myself and get out the shot, and I'm going to take you right outside the courthouse where you can hear this public safety announcement from Justin Timberlake himself.
Good morning, everyone. So I don't know how many of you were in the courtroom and heard what I had to say in the courtroom, but I'll reiterate that and say this to you. Many of you have probably been covering me for a lot of my life, and as you may know, I try to hold myself to a very high standard for myself. And this was not that. This was not that. I found myself in a position where I could have made a different decision. But I've had some time to reflect on that. And I also understand by, the fact that all of you are here, that I have a platform, you have a platform, we share that platform. And so what I'd like to say to everyone watching and listening, even if you've had one drink, don't get behind the wheel of a car. There's so many alternatives. Call a friend, take an Uber, there's many travel apps. So take a taxi. This is a mistake that I made, but I'm hoping that whoever's watching and listening right now can learn from this mistake. I know that I certainly have. And like I said, even one drink don't get behind the wheel of a car. I also said this in the courtroom before, but I grew up in a small town, so I can appreciate and understand the strain or unique nature that this must have been on the people of Sag Harbor. But I just want to say to everyone who's been involved, from everyone in the courtroom to everyone outside, including the police department, that I'm very grateful, and I thank them. And I guess in closing, I'd like to say we can all be more safe out there. And I'm going to do my part. I hope that everyone else does their part. And thank you very much.
Justin, have you spoken to Mel Cosby? Happy it's over.
And thanks to Justin Timberlake for that PSA. Bottom line, he said it. Even if you take one drink, don't get behind the wheel and drive. It's not good for yourself. It's not good for those drivers around you. It's not good for anyone. This thing with Justin Timberlake, as bad as it was, could have been a lot worse. Period. Point blank. In court Friday, a judge ruled that Maxwell Anderson will stand trial on 3 charges related to Sadie Robinson's homicide. A judge denied a request to separate an arson charge from the other 2 charges 33-year-old Maxwell Anderson faces, which means he's facing all 3. Anderson faces charges of first-degree intentional homicide, arson, and mutilating a corpse. Prosecutors say Anderson killed and then dismembered Sadie Robinson after a first date in early April, when she was reported missing. Another trial is scheduled for late October before the trial is set to start December 9. In July, a series of search warrants revealed disturbing new details about Maxwell Anderson's home. Pictures in the warrants show Anderson and Robinson on their first date at the Twisted Fisherman. The pair went to at least one more bar before the 19-year-old disappeared. And we now also know what evidence police found inside Anderson's home. That includes a Crown Royal bag with an ID belonging to a 27-year-old woman, a notebook with other women's names and information about them, and women's clothing hidden between basement support beams and in the foundation wall. Anderson was pulled over on April 4th in his 2013 Hyundai Santa Fe before it was towed. A detective observed what appears to be blood in the passenger side door speaker. Search of the car found a black brand folding knife, a wood-handled knife and cutting instrument, a bedazzled compact mirror, and a black jacket from the rear passenger seat. So to say Maxwell Anderson dug himself a hole that's just barely scratching the surface. Next up, the mother of Harmony Montgomery plans on suing the state of New Hampshire. The mother of the young girl whose murdered body has never been found filed a lawsuit against the state of New Hampshire and several of its agencies for her daughter's death. Harmony Montgomery was only 5 years old when she was beaten to death by her father, Adam Montgomery, coward, in 2019. She was reported missing for approximately 2 years. Adam was convicted of murdering her after he admitted to disposing of her body in a bag, a cooler, and a ceiling vent as he moved it around and hid it for months. Crystal Story, Harmony's mother, lost custody of the little girl while she was alive, but was declared the sole administrator of her estate following a hearing in March. Story had asked the state to declare Harmony dead and assign her as the administrator ahead of her planned lawsuit. On this past Friday, Story filed a lawsuit both as administrator of Harmony's estate and on her own behalf. The lawsuit targets the state of New Hampshire, the New Hampshire Division for Children, Youth, and Families, and the New Hampshire Department of Health and Human Services, according to records reviewed by Court TV. The lawsuit accuses the failures of the agencies named as beginning in 2018, before Harmony's death, when proper home studies failed to be concluded before Adam was awarded custody of Harmony by a Massachusetts court. Story also accuses the state of failing to properly investigate a report of abuse in 2019 when Adam's uncle said that Harmony had a black eye from her father. DCYF allegedly received a number of reports of the alleged abuse Harmony was suffering, but the lawsuit alleges the agency failed to follow up with some of the reporters and ignored glaring issues in the home, which included drug paraphernalia out and visible and electricity being cut off to the property. A note in one of the reports cited by the lawsuit says that a caller wondered whether DCYF was waiting for the children to die, quote unquote. The DCYF officer asked Harmony whether her eyes still hurt, and she said no. Whether she felt safe at home, and she said yes. Whether anything had happened that made her feel scared or sad, and she said no. And whether her mom, dad, or anyone else heard her recently or ever, and she said no. On information and belief, the officer conducted this interview in a public part of the home with others present, in violation of DCYF Policy 1201. On information and belief, the officer did not ask Harmony any questions related to the reports that she had been punished by being made to stand in the corner for hours, that she had been punished by being made to stay in a room for most of the day, or that she had been punished by being made to scrub the bathroom with a toothbrush. Adam told DYCF officers in January 2020 that Harmony had gone back to stay with her mother in November. According to the lawsuit, no attempt was made to contact Story to confirm the information for 12 days. When the officer left a voicemail and made no follow-up, the prosecutor said that Adam used a U-Haul to eventually dispose of Harmony's remains. They have never been found. Prosecutors in Story pledged to continue searching for her even after Adam's conviction. Adam was sentenced to life in prison without a possibility of parole. Kayla Montgomery, Adam's wife and Harmony's stepmother, witnessed the murder and testified at Adam's trial. She was released on prison on parole in May after serving the term of a plea agreement she reached with prosecutors. I sincerely hope that Crystal Story gets all the justice she can get in the name of Harmony. And as for that coward Adam Montgomery, he's right where he belongs. May he never see the light of day again. Justice served. Okay, guys. This one I have to file under at the very least one of America's dumbest criminals. Okay. This is not going to take long, but I want you to hear the article first before you see the footage. In what looked like a scene out of a movie, 2 jurors are credited with helping to capture a man who tried to flee from a main courthouse following his conviction. 31-year-old Nicholas Carter was convicted of aggravated assault against a 14-month-old child on last Wednesday at the Somerset County Courthouse following a 3-day trial, according to the Waterville Morning Sentinel. Carter had been out on bond during the trial, but immediately following the verdict, the judge ordered him to be taken into custody. Handcuffed, Carter then jumped the bar, ran out of the rear doors of the second-story courtroom. According to the Waterville Morning Sentinel, a detective from the sheriff's office and judicial marshals gave chase as Carter ran down the stairs and out onto the street. Security footage showed the chaotic scene as Carter made his attempt to escape. Carter was outside when he tripped and fell in a nearby yard. 2 jurors who had been in court helped subdue him until law enforcement arrived, and that's according to the Bangor Daily News. Now, Carter faces an additional charge of escape, and his sentencing will be held at a later date. So now, normally I would take myself out the shot, but this one I want to enjoy with you. So what I'm going to do is this. I'm going to quickly flash the copyright disclaimer. Okay? We're good? Alright. Now you may not get any sound of this, but just see it here. Here the chase, literally the chase is on. Nick Carter trying to get out. He's still handcuffed. He's making sure, I'm not going to jail for this. Whatever it is, I'm getting out of here. Right straight to the parking lot, and there's the 2 jurors they're giving chase, and that's where he trips up. He gets busted. And just as sure as I'm reloaded, that's what happens. You run tired, or you run and trip up, and still you end up getting caught. Nicholas Carter should just went into custody of the deputies in the courtroom. Then none of this would have happened, and I would have had nothing to show, let alone talk about. Well, just when you thought you had your shot to escape, all right. I won't do the show a video for the next one. But the driver charged with killing NHL's Johnny Gaudreau and his brother cries in court. The prosecutors say Sean Higgins had a blood alcohol of .087 when he hit and killed the NHL player and his brother. Alright. The driver charged with killing hockey player Johnny Gaudreau and his brother Matthew as they bicycled on a rural road at a blood alcohol of .087. just above the .08 legal limit in New Jersey, a prosecutor said Friday. 31-year-old Johnny and brother Matthew, 29, were killed in Carneys Point, New Jersey on August 29, the evening before they were set to serve as groomsmen at their sister Katie's wedding. The driver, 43-year-old Sean M. Higgins of nearby Woodstown, New Jersey, is charged with 2 counts of death by auto, along with reckless driving, possession of an open container, and consuming alcohol in a motor vehicle. At a virtual court hearing this past Friday, a judge ordered that he be held for trial despite defense arguments that he was a married father and a law-abiding citizen before the crash. I stopped there to say, in a case like this, everybody is a law-abiding citizen until they're not. He's an empathetic individual. He's a loving father of 2 daughters, said defense attorney Matthew Portella. He's a good person and he made a horrible decision that night. Higgins told police he had 5 or 6 beers that day and admitted to consuming alcohol while driving, according to the criminal complaint. He also failed a field sobriety test. The complaint said. A prosecutor on Friday said he had been drinking at home after finishing a work call at about 3 p.m. and having an upsetting conversation with a family member. Higgins also had a history of road rage and reckless driving, according to First Assistant Prosecutor Jonathan Flynn of Salem County. He said that Higgins apparently became frustrated when the 2 drivers ahead of him slowed down to go around the cyclists and sped up to try to pass them on the right, striking the Goudreaus. He indicated he didn't even see them. Superior Court Judge Michael J. Silvanios, who said Higgins admitted impatience caused 2 deaths. Higgins faces up to 20 years, a sentence that the judge said made him a flight risk. Higgins has a master's degree, works in finance for an addiction treatment company, how ironic, and served in combat in Iraq, his lawyer said. However, his wife said he had been drinking regularly since working from home, and told them he had a history of driving like a nut, prosecutors said. Johnny Goudreau, known as Johnny Hockey, played 10 full seasons in the National Hockey League and was set to enter his 3rd with the Columbus Blue Jackets after signing a 7-year, $68 million deal in 2022. He played his first 8 seasons with the Calgary Flames, a tenure that included becoming one of the sport's top players and a fan favorite across North America. Widows Meredith and Madeline Goudreau described their husbands as attached at the hip throughout their lives. Both women are expecting, and both gave moving eulogies at the double funeral last Monday. And I can say that I had the privilege of watching a tribute to both of these brothers on an edition of Monday Night Raw on last week, and from everything I've heard, Johnny Goudreau, his brother Matt, 2 stand-up guys, 2 good guys, and that shouldn't have happened to him. In fact, I shouldn't even know their names because I don't even watch hockey. So, my thoughts and prayers, my deepest sympathies go out to the Goudreau family. And I pray not only for justice, but also pray for peace and closure that may come after. Finally. I was at work when I got this report, when I saw this press conference. That the remains found on private property I'll tell you what. Instead of me reading about it, instead of me just trying to talk about it, one last time I'm gonna put up the copyright disclaimer. I'm gonna mute myself and I'm gonna take myself out of the shot, and I'm gonna take you to breaking news in this press conference, leading off with Judge Ashley Wilcott and Michael Ayala of Court TV.
All right, folks, as we said, we're taking you out to that news conference out in Wisconsin where police are holding a conference in the case of 3-year-old missing Elijah.
I would like to first thank you all for taking the time to be here, and also to those of you watching or listening in. Your unwavering concern and support for Elijah has been greatly appreciated by all of us. Today we're holding this press briefing to provide you updates in regards to the search for Elijah Vu. Since the moment that we took the call on February 20th of this year for Elijah Vu being missing, Elijah has been our top priority and will remain our top priority. Because we are committed to open and honest communication with our community, we are holding this press briefing. Chief Ben Meinert of the Two Rivers Police Department will be sharing important updates with you all. Meinert's last name is spelled M-E-I-N-N-E-R-T. We will not be taking any questioning during or following the press briefing because we are already sharing all of the information that we are able to provide to you at this time. There will be a packet available for you containing the information that Chief will be sharing, and I will provide that to you following the press briefing. Chief Meinert.
Thank you all for being here. Last Saturday, Sheriff Hartwig called me immediately upon learning his deputies were responding to investigate a report of skeletal remains found by someone in the town of Two Rivers. With night falling near, the entire area was secured while a variety of resources were gathered to investigate. Ultimately, a forensic anthropologist with the Wisconsin State Crime Laboratories was able to confirm a skull and bones as human remains. On Sunday, my staff assisted the Manitowoc County Sheriff's Office, Department of Justice, Division of Criminal Investigation, and the Wisconsin Crime Lab with recovery of those remains and any associated evidence. The intentions of our team were to first notify family of the discovery and then alert the public. Prior to that, however, reports went out on social media and other platforms, some of which were false and most of which had yet to be confirmed. While we do feel it's important to share information with the public, our first priority is Elijah and the integrity of the investigation, as well as communication with the family. These are the facts that I can share. The remains were found on private property by a person getting his land ready for the hunting season. This land was not on Manitou Girl Scout camp property, but rather a thick wooded area with heavy underbrush, just to the north of Manitou. This location is just over 3 miles northwest where he originally was reported missing. This area had been searched several times, as had been reported, by law enforcement searches, by private searches, by the landowner, by air, and with various search and rescue teams. Despite all his previous efforts and throughout different conditions and changing seasons, we continued searching and even had continued searches scheduled as early as next week. The remains found by the hunter and recovered by law enforcement were taken to the Wisconsin Crime Lab for DNA testing to identify the person. It is with a heavy heart that I announce to you today, those remains were identified as Elijah Vu. With that news and following this briefing, the Amber Alert will be canceled. As soon as Elijah was identified, we notified his family. I ask that you respect them and allow them to grieve. The area where Elijah was located is private property, and we ask that you respect the private property owner and avoid that area. This is not the outcome that we hoped for. The family's devastated, we're devastated, our community's devastated. I never met Elijah, but I watched that 3-year-old boy bring out the best in this community. I can't thank the public and our businesses enough. Thank you, DCI, for continuing to lead this investigation, FBI for their support, and our local, state, and federal law enforcement and fire departments, as well as the numerous neighboring agencies. I'd also like to thank all the churches, schools, all the search and rescue groups, and our residents and the family members. Thank you to all that the various city employees have done. The efforts of all of you and many others help bring conclusion to this phase of the investigation. What started out as a search for a missing boy is now a death investigation. Although we understand your desire for information, we can't share every detail, and we must maintain the integrity of the investigation. We know the family and the community has a lot of questions. This is a process that will take a great deal of time, and we'll do everything we can in this investigation to answer those questions. Going forward, we'll continue to share updates provided from DCI and the Manitowoc County DA. We will receive them, and we will continue to be your sole source of accurate information. Now that we know the location of where Elijah was located off Christy Bob Lane and Manitou Drive, we ask that anybody with any information, if you haven't previously provided it or you think it may be useful in this investigation, to please contact law enforcement. Again, my assistant chief will provide you with the information on how to do so if you can. And again, thank you all for being here.
Can we expect a death investigation or autopsy?
Sorry, as a reminder, there will not be any questions.
That autopsy results be confirmed?
As Chief said, if you have any information that you feel would be beneficial for this investigation, please contact Detective Lieutenant Glazer of the Two Rivers Police Department at 920-686-7200. Again, that's Detective Lieutenant Glazer, Glaser, at the Two Rivers Police Department at 920-686-7200. As Chief Meinert said, we too are devastated by this news. Elijah was a little guy, but he left a huge impact on all of us, and he will not be forgotten.
You know, Michael, it's such a double-edged sword. It is so sad to think it's now gone from a missing person to a death investigation. On the other hand, the unknown has been answered, and now begins the investigation to seek justice. He's been missing since February 20th of 2024.
Yeah, no doubt about it. Again, talking about finding him or finding the remains in a heavily wooded area. It was found on private property. There have been some misinformation about exactly where it was found. used to be a public, they said it was a public campground, but actually it was private property. That was wrong. But here's the key, 3 miles northwest from where he was reported missing. And we do know that right now, Katrina Bauer, Jesse Vang being held on charges of child neglect. We didn't hear anything about charges in this case. But remember, Jesse Vang's story is that he was with him, he fell asleep, and when he woke up, the child was gone. So again, they need to dot their I's, cross their T's before they go and charge anyone to make sure that, you know, what happened to this young boy.
And there are going to be a lot of forensic questions. So we know there was a skull and bone that were identified as human remains, now identified as Elijah Vu. But Michael, what about the rest of the remains? And can they determine cause of death from that? It may be that there's too much decomposition. We don't know any of that yet. Certainly, that's part of that ongoing investigation.
Yeah, absolutely, and you're exactly right. I think what the results of whatever forensic information they're able to get from the remains would be very important to this investigation, figuring out how he died. Because what we do know about when he was with Jesse Vang is that his whole role in this young boy's life, it seemed, at this point, was to discipline him. And he was disciplining him in ways that just didn't make any sense, and rightfully so, he is being charged with child neglect, and his mom as well. So again, that will tell us a lot. A forensic pathologist identified that, a forensic anthropologist was the one that did the testing. They ultimately did DNA testing and found out that they did in fact belong to Elijah Vu. And I just have to say, I agree with you 100% because I'm sitting here listening to what had happened, and I said to myself, is this a happy thing or a sad thing? Because again, there's closure, right, for the family, but the worst kind of closure, right? And sadness goes along with finding out.
Very sadness, respecting the family, respecting the privacy of the landowner, who certainly I don't think was involved at all. It's just where the body's been found or the remains were found.
I want to thank Court TV's Judge Ashley Wilcott and Michael Ayala, and I want to thank the Two Rivers Police Department for the press briefing in regard to those missing, those remains belonging to Elijah Vu. And if you followed me all the way to at this point of this edition of Bethea'S Byte Reloaded, and you happen to figure out it would be this story, this development, that would be the story that tore my heart in two. Congratulations. You're as sympathetic as I am. Now, I want justice for Elijah. In fact, I'm going to go ahead and I want to kind of sort of tag it here for everyone to see. That I stand for this. I kept my word that I would keep Elijah's name out there until he was found one way or the other. I was praying the whole time that he would be found alive, but I see now that that's not the case. So now we seek justice. If that means giving time to Jesse Vang, time to Katrina Bauer, just for neglect, then so be it. Elijah View deserves justice. And that's the bottom line. Alright guys, that's going to wrap it up for me for this edition of Bethea'S Byte Reloaded. I sincerely want to thank you all for joining me. And I'm going to go ahead and, as I didn't do this earlier, I'm going to go ahead and give you all how to get in contact with me, because I know you're going to have a lot to say on a lot of the stories presented here. So, if you want to hit me up on Facebook, I'm at Bethea'S Byte Reloaded. I'm on X at EKB316. That's in all caps. I'm here on YouTube at Bethea'S Byte Reloaded. I'm on Instagram at EKB316. That's all lowercase. On TikTok at King of Hearts 316 2021. And of course, you can email me. The address is kingofhearts316_09 at outlook.com. What's all these good goodies?
You get 3 shots.
Oh, 10% off grocery coupon. Great. All right, guys. Just remember, this is the place. This is the place I've been telling you about. This is your home for true crime news without the drama, where your opinions matter, where lively debates are encouraged, where your voice is heard, and above all else, justice served. This is Bethea'S Byte, and it's reloaded. I'm Ernest Bethea, the last outlaw. Again, thank you all so much. And until we do this again, you know what to do. Bite. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe to the channel, and drop me a comment on this video. Also, be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.